Right, we begin here. Chairperson of the Commission of Inquiry into State Capture, Deputy Chief Justice Raymond Zondo, says he will issue another summons for the former President Jacob Zuma to appear before the Commission and will approach the Constitutional Court for an order to compel Zuma to answer questions. Zondo says he will also lodge a criminal charge with the police against Zuma after he left the Commission last week. Zuma and his legal team walked out after Zondo dismissed the former president's request for the Commission Chairperson to recuse himself from the hearing, from hearing Zuma's testimony. Zuma had accused Zondo of being biased and said the two shared a close relationship, which Zondo denied several times. Zondo explains his immediate move.
Given the seriousness of Mr. Zuma's conduct and the impact that his conduct may have on the work of the Commission, and the need to ensure that we give effect to the constitutional provisions that everyone is equal before the law, I have decided to request the Secretary of the Commission to lay a criminal complaint with the South African Police against Mr. Zuma, so that the police can investigate his conduct, and in this regard, the Secretary would make available to the police all information relevant, as well as make information available to the National Prosecuting Authority. Most of the evidence is available because the proceedings of this commission were live on television, and exactly what happened from the time I began to deliver my ruling up to the time I adjourned the proceedings would be available. Apart from that, the Commission is going to take certain steps. One, I am going to determine other dates when Mr. Zuma must appear before this commission. Two, the Secretary will issue a summons to be served on Mr. Zuma to appear before this commission during those dates. Three, that summons will be served on Mr. Zuma. Four, the Secretary of the Commission will make an application to the Constitutional Court on an urgent basis for the Constitutional Court to issue an order that will compel Mr. Zuma to appear before the Commission in accordance with the summons that will be issued. In other words, to comply with the summons. And when he attends the proceedings of the Commission in compliance with the summons, not to leave the proceedings without my permission. The order that will also be sought will include an order compelling Mr. Zuma to comply with directives that have issued in terms of Regulation 10.6 of the regulations of this Commission, which were promulgated by Mr. Zuma when he was still president, which require him to furnish certain affidavits to the Commission. That is what is going to be done. This Commission is quite clear about the steps that will be taken.
All right, for more analysis on that, we welcome via Zoom Jabu Mabuza, attorney and director at Thandolethu Mabuza Attorneys. A very warm welcome to you, Mr. Mabuza, and thank you so very much for being with us here on SA Today. Let's talk about the legal ramifications of what we've just heard, what the Deputy Chief Justice Zondo had to say earlier today, saying that not only am I not recusing myself, but I'm actually laying a criminal charge or a criminal complaint against the former President Jacob Zuma. Let's go through the legal ramifications.
Okay, now thank you, Flo, and good day to your viewers. Flo, if we remember and we go back, that the commission was established in terms of the Commissions Act of 1947. So part of the act, and I think it'll be Section 2, says that the commission has powers to summon a witness to come and appear, and then when you go down with the act, it then says that the commission also has powers to lay the criminal complaint if somebody leaves the commission without being excused or does not answer the questions satisfactorily. So that's what empowers the Deputy Chief Justice to issue the summons again, and to also seek the order that he seeks, as well as just directing that the National Prosecuting Authority and the South African Police Services be part of this.
Yeah. Will this not come across as personal? I mean, throughout last week, we were hearing, the former president talking about this supposed friendship, and of course, the Deputy Chief Justice denying that there's any kind of a friendship. The fact that the Deputy Chief Justice has now taken this a step further in saying that he is going to lay this criminal complaint, will this not come across as rather personal? And I wonder if it's been done at a commission before, in terms of giving weight to the issue of his recusal, which is what the former president had requested. Does this not give weight to that request?
I think maybe the beauty of the Deputy Chief Justice referring the matter to the South African Police Service is that the contempt proceedings are different, and the contempt proceedings, in terms of the Commissions Act itself, the former president will have an opportunity to ventilate those issues and say that this is how I perceived things to have been. Because, Flo, we need to separate what is ethical, what is moral, and what is legal. I don't think that on a legal standing, if I was representing the former president, I would also allow him to continue with the proceedings, because if we're going to review something, then one imagines that the order is stayed. Because if the former president continues to give evidence that will, when the review court hears the matter, the review court will overturn that decision, then it would have been wasteful expenditure.
Yeah.
But again, the former president was summoned to the proceedings and ought to have respected the former deputy chief, the Deputy Chief Justice, and asked to be excused, even though they proffer a reason as to why they're excusing themselves. But they were there not by invitation, but by summons. So they ought to have stayed until the Deputy Chief Justice excuses them.
Now you put yourself in the shoes. You put yourself in the shoes of the legal representative of the former president, and I just want to interject here and in fact carry on in that light. If you were the legal representative of the former president, what would your game plan have been? Because I can imagine that the legal representative, his advocate, would have known that there are repercussions to walking out of the commission. And obviously, the Deputy Chief Justice would not have taken that lying down. So I'm imagining that the advocates kind of would have known that something would have happened. Do you think this was perhaps part of the plan so that these issues could then be ironed out, in a criminal matter?
I don't think that they wanted to intentionally disrespect the Deputy Chief Justice. And if you look at the proceedings, Advocate Kakane gets up and he says that we are giving you this explanation so that it cannot be seen as though we are walking out, and these are the reasons for us leaving. But also remember, Flo, that you don't want your client to sit in the stand, and when they give testimony, they can't give full testimony because like how it happened with the former SAA chair, where you need to say that I don't feel comfortable in saying this and I don't feel comfortable in saying that because you've raised what would be or what you feel is bias, So I think one of the reasons that they took into consideration is the fact that having him sit on the stand would have a negative light when the Deputy Chief Justice considers all the evidence that that the former president has given at the commission. So I think they had considered it, and I don't think that they imagined that it would get to this stage.
Yeah.
Because there are also some talks that happened in the chambers. When we were watching the proceedings, we were told that there were talks that happened in the chambers. So we don't know what transpired there. So there's another element to this.
And just to sort of ask you to look forward in terms of what you kind of anticipate from a legal perspective, how this will kind of play out, because this is obviously then going to draw the issue even further than it has already been long drawn out to begin with, and might even delay the commission further, as many situations have caused the delay of the commission. I mean, for goodness sake, we had COVID this year that really caused the commission not to really meet the deadline that they would have anticipated at that time. But how do you see this kind of playing out, just really from a legal perspective?
So legally, I think that the game plan is for the president to not take the stand. But on a moral and on an ethical standing, I think it would be good for him to take the stand, because I think if not over 22 people have implicated him, and the commission is a fact-finding commission, so they need to find out what actually happened and give recommendations. So you'd want the president to sit, but again, the commission is now running against time because the commission needs to wrap up its work, I think, sometime next year. So they've got now that dilemma of time, as you say, that even COVID hit. So they would want the president to sit, but again, the law protects even those that we don't like. So the former president is within his rights to apply to the review courts to review the decision of the DCJ, and that is within his rights. Just like it's within the rights of the commission to launch the contempt proceedings. However, the contempt proceedings will run parallel with the summons or the application to the Constitutional Court. So he cannot come, or the former president can't say, I can't answer because there are contempt proceedings. So on that front, I don't think it will delay the commission. But when the former president does launch the review application, then he cannot take the stand, because he would want to have that ventilated.
All right,
before
Jabu,
sitting and answering any questions.
All right, Jabu, thank you so very much for giving us your time here on SA Today. We look forward to catching up with you next time. Thank you so much for your time, sir.